5e séance du Comité permanent de la citoyenneté et de l'immigration.
Welcome to our committee. Order, please. This is the Standing Committee on Citizenship and Immigration. First of all, apologies on behalf of the committee and all its members for this delay. It is very unfortunate we were unable to begin at 3:30 as planned. Consequently, we will unfortunately not be able to give each one of you as much time. However, it is important for us to hear all of you. So the groups will each have 3 to 4 minutes for their presentation, and based on the time remaining, we will then move on to a question and answer period with the members around the table. We will begin with Ms. Elke Winter, who is speaking to us from Paris. Because of technical issues, we want to ensure that you have the floor first, because I have been told you won't be able to stay with us beyond 5:30 or up to 5:30, at which time the committee will end. So appearing by video conference from Paris, France, as an individual, Ms. Elke Winter, Associate Professor of Sociology, Department of Sociology and Anthropology, University of Ottawa. Ms. Winter, you have 3 to 4 minutes for your opening statement. Thank you. I will be speaking in English, but you will be able to put questions.
To giving me the opportunity to speak to you about Bill C-24. In my testimony, I would like to offer you a sociological perspective based on past and ongoing research. I will start with 3 statements that are widely accepted in academic scholarship. First, immigration is a fundamental element of Canadian nation building, and Canada is widely regarded as having practiced this type of nation building with great success. Second, the Canadian immigration system is to a large extent driven by economic considerations. Canada practices what former French President Nicolas Sarkozy has called, with much envy, immigration choisie et non pas suivie, meaning Canada selects a large part of its migrants according to rational economic criteria. Third, economic migration and nation building only go well together if the harsh utilitarian selection of migrants is complemented by a warm welcome. In this sense, multiculturalism as a policy, discourse and form of national identity has done its fair share of signaling this warm welcome to immigrants. The encouragement of immigrants to quickly take up Canadian citizenship extends this welcome. Research has shown that holding citizenship of the country where one resides is a huge factor for achieving employment at one's skill level. There's also evidence that citizenship fosters feelings of belonging. If I'm not mistaken, these are all elements that the Canadian government wants to achieve. By contrast, Bill C-24 seems to suggest, let me just rephrase. I'm just skipping some of my notes here to get in the time. Some elements of Bill C-24 risk undermining Canada's success in immigration in nation building. Citizenship should always be viewed as an important step towards integration. By contrast, Bill C-24 seems to suggest that citizenship is an endpoint or reward of integration. From a sociological point of view, this approach has at least 3 flaws. First, for the less educated, the non-European language speakers, and the economically vulnerable, it makes citizenship much harder to obtain. The more difficult citizenship test and stricter language rules create barriers, specifically for accompanying family members, often women. The new cumbersome residence questionnaire is particularly difficult to comply with for citizenship candidates who come from politically unstable countries or from countries with less developed bureaucracies. Some may feel discouraged to apply for Canadian citizenship due to high application fees and the need to submit income tax assessments. Bill C-24 would also limit partial credit towards the residence requirement for students, refugees, and former temporary workers. It thereby bars an increasing portion of migrants to Canada for having access to citizenship. This is not only ethically dubious, but also not conducive for nation building. Second, for the highly skilled and highly mobile, the so-called best brains in the world that Canada wants to attract, Bill C-24 also prolongs and discourages the obtention of citizenship. The longer resident periods may be too long for those who are highly mobile and are looking for a place to settle. Not being encouraged to become Canadian citizens quickly, they may opt to behave as rational and utilitarian as Canada did in selecting them. They must just leave for a place where they can get a better pay for their skills. This is counterproductive to successful nation building. Those who are highly mobile and able to create offshore business opportunities are particularly penalized by the proposed physical residence requirement. Let us not forget, Physical presence in the country is only a proxy for attachment, loyalty, and feelings of belonging. Hence, it should be treated with flexibility and a sense of proportion, presumably by a citizenship judge.
Madam Winter, I will ask you to conclude quickly, please. Thank you.
Yes, okay. I have my third point, and then I'm concluding. Regarding those who aim to commit terrorist attacks against Canada, is it doubtful that the proposed law contains anything that would deter them from their actions? Research suggests that perpetrators seldom refrain from heinous crimes due to drastic penalties, not even the death penalty. Further, the discourse of fear and the raising of suspicion against dual nationals have detrimental impacts upon some communities, particularly upon Muslim and Arab Canadians. With a team of researchers at the University of Ottawa, we're currently investigating the public debates that were kick-started by the Honourable MP Vinda Shori's Bill C-425. And while our investigation is ongoing, I can already tell you that it led to numerous rants against Muslims in Canada, in the print media, online fora, and social media. Bill C-24 extends and amplifies these negative stereotypes. I will conclude here and send you my notes.
Thank you, Madam Winter. Yes, as you just stressed, all our witnesses can send their notes to the clerk, and we'll make sure that all the members of the committee will receive it and can read it. Thank you very much. Our next witness is Ahmadiyya Muslim Community Canada, Mr. Ashif Khan, National Secretary, Public Affairs, and Mr. Imtiaz Hamid, Regional Public Affairs Secretary and Missionary. You have up to 4 minutes.
Thank you. I'll try to be quick. I've cut much of this out. I'm honored to be here again. Ahmadi Muslims, whether they are citizens or residents of Canada, are proud to be so. We embrace Canada as our home and embrace Canadian society and its values. Canadian citizenship is valued by our members, and we are aware that it's perhaps the most coveted in the world. After our modest review of the bill, we would like to provide our endorsement to the bill and its aims to reinforce the value of Canadian citizenship. I will, however, provide some comments for your review. Before I provide my comments, I would like to mention the Islamic teachings as it relates to loyalty to one's country of residence. The Prophet of Islam, Muhammad, peace be upon him, himself once stated, "Love for one's homeland is part of one's faith." It is not a mere civic responsibility on its own, but more importantly, it is to form a part of one's spirituality and faith. Further to this, His Holiness Hazrat Mirza Masroor Ahmed, the current worldwide spiritual head of the Ahmadi Muslim Jamaat, has further elaborated on the noble precept by guiding Ahmadi Muslims all over the world with the following words, and I quote, "As citizens of any country, we Ahmadi Muslims will always show absolute love and loyalty to the state. Every Ahmadi Muslim has a desire for his chosen country to excel and should always endeavor towards this objective." And about Canada in particular, His Holiness echoed the prayer of our fourth Caliph, and that is, the whole world becomes like Canada, and Canada becomes the whole world. Ahmadi Muslims understand the worth of Canadian citizenship and what it means and affords to the residents of this country. So, I'll just skip this part. This is why we're at the forefront in giving back to our country and serving our communities. Speaking specifically to the certain parts of the bill, I would like to reiterate that we feel that it is essential that the Canadian government possess certain powers to deter such would-be transgressors against the state from committing acts that threaten the security of this country. To this point, His Holiness also commented during his 2012 visit to Canada, where he said, "Indeed, for the entire world to become Canada, we must keep a vigilant eye on all forms of extremism and extremists." And in doing so, His Holiness recognized, even led the way in informing Canadians about the need to protect from the threat of extremism. However, and we realize that the bill does not necessarily touch upon this, but we feel that the bill comes short on addressing the permanent residency applications of such extremists. Detecting extremists who apply for residency must be detected in the early stages and not after residing here. Regarding this, His Holiness advised the government in the same address with the following words, where he said, "I would like to draw your attention towards to one matter in particular. This government should be aware that it is quite possible for certain extremist elements to enter the country on the pretext of benefiting from the various investment opportunities or schemes of the government. The risk should be kept in view by the policymakers when determining future immigration and investment policies." Further, he goes on to say that no doubt the eyes and glances of those who hold extremist ideologies are cast upon this country. It is not necessary that they will conduct a large-scale terrorist attack, but instead they may take a more subtle approach whereby they will seek to gradually spread their hate-filled ideologies upon entering the country. Certainly one common and relatively easy way of entering the country is on the pretext of business and trade and investment. And we feel that's not really being addressed in this bill, and again understanding that it's not necessarily the scope of the bill. We realize that it would perhaps make immigration applications more stringent for acceptance to Canada for our members and members of other communities. Speaking again specifically to the bill, some concerns have been raised by MPs in the discussions. We would like to draw attention to some of these cautionary remarks and recommend that adequate...
Sorry, Mr. Ken, you have a few seconds left if you can summarize. Thank you.
In regards to the non-permanent residency requirement, we feel that there should be a reward for choosing Canada for work or studies. It shouldn't be a deterrent for some talented individuals who can choose other Western nations as a place to work or to study. And in regards to the age requirements, we feel it's just an added complexity to further the extension of the ages from the beginning and from the end. And at the same time, a talented member, a contributing taxpayer who's highly proficient in his work and study and in another language shouldn't be denied residency or citizenship just because it's not English or French.
Thank you, Mr.
Okay.
I'm sorry I have to stop you here, but hopefully you have time to say more during the question period, and you can submit your notes to the committee too. Our next witnesses are pre-PR time counts with Taisia Shribakova, representative, and Maria Smirnov, representative. You have up to 4 minutes.
Thank you. Dear honorable members of the committee, we're extremely thankful for the opportunity to make selected comments on the Section 3.1 of the bill, which eliminates Section 5.1ci of the current Citizenship Act by taking away pre-permanent resident time counting toward the citizenship application. First, I would like to introduce myself and my colleague. My name is Taisia Shribakova. I've been in Canada for 10 years, and I'm currently a permanent resident. Under the current citizenship and immigration law, I will be eligible to apply for citizenship in less than 100 days. I'm here together with my colleague, Maria Smirnov, who is a Canadian citizen since 1998. Together, we represent pre-PR Counts group that has received support by thousands of Canadians through our online petition, as well as vast media coverage. The proposed legislation concerns us in a group in the following 3 ways. First, it diminishes the value of economic and social contributions made to Canada by international students and temporary foreign workers. Second, it actually favors immigrants without Canadian experience. And third, it puts Canada at a competitive disadvantage relative to its peer countries. Let us now elaborate on each of these 3 points. What differentiates international students and temporary foreign workers from other immigrants is that they're not newcomers to Canada. They have already established strong economic and social ties within the country by graduating from Canadian universities or working in Canadian companies, owning properties, paying taxes, and in other words, they have become fully Canadianized, as described by Honorable Francis Muldoon, a respected Canadian immigration judge, even prior to becoming Canadian permanent residents. Maria?
Thank you. Second, by eliminating the pre-PR time provision, the new legislation actually favors immigrants without prior Canadian experience. Let me explain this by giving a simple example. Imagine 2 individuals who receive their permanent residency today. One of the persons have been in Canada for over 5 years. He graduated from a Canadian university, works for a Canadian firm, and has been fully participating in Canadian society. Another person just arrived to Canada today and received permanent residence at a point of entry. For him, Canada is a new country where he does not have any social or economic investment. Currently, the first person will be eligible to apply for citizenship in just 2 years from today, the second person in 3 years. With Bill C-24, both individuals will have to wait at least 4 years before applying for citizenship. So the individual with the Canadian experience is no more advantage than someone who just arrived to Canada today. So to summarize, Bill C-24 will increase wait time for someone with Canadian experience by 2 years and only by 1 year for someone without previous Canadian experience. Bills that change the playing field equally for all groups are not objectionable. Bills that take away something valuable from one group and not others, that's the type of bill that we need to look more closely at. Therefore, we ask, how is the elimination of counting of pre-PR time help strengthen ties to Canada for someone who has lived here for 5 or 10 years? Or how, and precisely by how much, will the processing time be reduced by eliminating of pre-PR time counting? Our third point is that the elimination of pre-PR clause puts Canada at a relative disadvantage as an immigrant-accepting country relative to its peers like Australia, UK, Germany, and others. These countries recognize that former students and temporary foreign workers are the best candidates for future citizens. and it allows them to count temporary residence time 1-for-1 towards their citizenship application. For example, Australia allows 3 years of pre-permanent residency time, 4 years in UK, and 8 years in Germany. In conclusion, we ask that the committee make the following recommendation to the government so that the government can achieve its vision of a strengthened Canadian citizenship. First, we ask the government to implement a transition period for the coming into force of the new residency requirement. This has been a common practice in other Commonwealth countries that undergo citizenship law reform, for example, Australia and New Zealand. We also ask that the government continues to recognize temporary residence time 1-for-1 based on practices of other peer countries. In making these recommendations, we ask the committee to be judicial and recognize that we have lived here, worked here, studied, and paid taxes here. We have chosen Canada to be our home long ago, and in doing so, we have had the opportunity to fully Canadianize ourselves, which is arguably the most important element of consideration when the grant of Canadian citizenship is considered. Thank you.
Thank you very much. Our next witness is from National Forum for Civic Action, Mr. Bikram Lamba, Chairman. Sir, you have the floor.
Thank you. Well, I would not take long time because I think my speaking notes have already been circulated to the members. But definitely some ideas, and maybe they'll be very politically incorrect. But that's very important. We have got to be very honest and call a spade a spade. The first thing is that the immigration or the citizenship, when the immigrants come, the way I came, it's always a matter of choice. It's not a compulsion. So when the immigrants come, it's their bounden duty to understand the Canadian values and the Canadian systems. And the so-called political correct attitude of showing them accommodation must not be there. This is putting the real Canadians, the original Canadians, at a disadvantage, this show of accommodation. Secondly, I know that former Minister Jason Kenney did cause some sense of deja vu as far as the reformation of the immigration system was concerned. But this bill doesn't go the whole way it should have gone. The so-called evidence of citizenship. It is half-hearted evidence that is required by the minister. One of the important parts he has forgotten is that Canada has got 2 official languages, English and French. And when we say that they should have some understanding of a language, official language, we are not being honest to ourselves. We must ensure that anybody who wants to be citizen must be proficient, and I repeat, must be proficient in one of the official languages. Imagine last year in Ontario alone, $378 million was spent on providing services like translation and interpretation. Why should the taxpayer pay to show that help to those immigrants? Second, as a matter of fact, anybody who doesn't know the official language has no right to be a citizen. Second part is the so-called family reunion. We are under a mistaken notion that the seniors need to come here. They don't want to come here. They are forced to come here. We shall be doing an act of mercy to them so that they are not transplanted here and be a burden on the economic system of the country. Thirdly, the social welfare system is a big burden on the society, and the taxpayer pays for that. Any permanent resident who goes on social welfare should immediately lose his PR status. That's what we feel. Because he's not contributing. He's just a burden. One thing which I liked was that the person who is guilty of treason or terrorist activity abroad, his citizenship is to be revoked. What about the victims of domestic violence? Under the so-called cultural accommodation or the multicultural help, we permit those people to exploit their wives, children. Why should they not? Their citizenship not be revoked. It's a very hot potato, revocation of citizenship. Secondly, you revoke the citizenship of a new immigrant. What happens to a second-generation citizen who is born here and he has nowhere else to go? The third is the change of the service. By the way, one thing I'd like to add, that the original one bill moved by one of the MPs, Davinder Shori, where service in the armed forces was a prime need that should be stressed again and again.
I would ask you to conclude, please, sir.
Just 1 minute more.
You have a few seconds. Thank you.
As a matter of fact, there's another point for the revocation. That's any citizen who gets an elected office in a foreign country must lose his citizenship. No person can be loyal to two countries. You can't be loyal to two spouses. How can you be loyal to two countries? So that must be revoked. And lastly, the power given to the minister under the title of compassion, that he can do anything, must be withdrawn. Compassion would always be misused. Saying that, I'll be open to any questions. Thank you.
Thank you. Thank you, sir. And our next witness is here with us as an individual, Mr. James Bissett. You have the floor, sir.
Thank you, Madam Chairman. I'm very pleased to be before the committee. I remember the 1977 Act when it was passed, and that was almost 40 years ago. So I think it is time that there be some changes in the legislation. I'm also pleased to see that we've extended the waiting time by at least 1 year. I argued in 1977 that we shouldn't have abandoned the 5-year wait. I think 3 years has been too short a period for people to really know enough about Canada and our cultural systems to apply for citizenship. So I approve of that change, even though it doesn't go quite as far as I might have wanted. It does bring us pretty well in line with most of the other countries of Western Europe, although I think all of those countries require longer periods than simply 4 years. Norway, I think, is 8. England is 5. The United States is 5. Australia. But we're getting closer to that. I also support the measures that would enable us to remove the citizenship of someone who is a dual national but who has committed treason or other treasonable or terrorist acts. I think that's a sensible position, and I can't see anyone opposing that. Any Canadian citizen who is prepared to commit acts of terror against his fellow citizens, I don't think deserves to continue to be a Canadian. We have to make it dual citizen because Canada has been a signatory to the Convention against statelessness in 1954 and then again amended in 1961. I think many people would think we should take it away from anyone, whether they're a dual citizen or not. However, I support that measure. It also brings us into line with all of the countries of Western Europe, with the exception of Portugal. But all of the other countries of the European community have now provisions in their legislation to remove the citizenship of anyone who commits treason or acts of terror. In England, that power is given to the Home Secretary alone, and there's no hearing. He can simply remove the citizenship of anyone that are not. A naturalized citizen, of course, is someone who makes a conscious choice to adopt Canadian citizenship. He makes an application. If he complies with the requirements, he takes an oath of allegiance and becomes a new citizen. I think that difference is with us whether we like it or not. It isn't a question of being second class. It's a question of being in a different category. And the provision of naturalization creates a difference between the two.
We'll ask you to conclude quickly, sir. Thank you.
Well, that's basically what I wanted to say. I support the bill. I think it's an opportunity for the committee to really make some fundamental changes in the law and improvements in it, because as you know, we may have to wait another 40 or 50 years before another change is made. So it's important that you get it right this time. Thank you.
Thank you, Mr. Bissett. We're now going to the question round with Mr. Menegakis. Sir, you have... sorry, I didn't see that you were arrived. Of course, thank you for reminding me. We have with us as our last witness for today, Madame Patty Tamara Leonard, Assistant Professor, Graduate School of Public and International Affairs, University of Ottawa. Madame, you have the floor for 3 to 4 minutes.
Thank you very much for inviting me back to speak to the committee. And I think actually what I'll do, I have many things to say, as do many people here, but I'll respond directly to Mr. Bissett's comments for the purposes of discussion. The Act as it is currently written proposes to permit the right to revoke citizenship in cases where an individual who possesses dual citizenship engages in a range of acts against Canada and where they allegedly fraudulently attained citizenship in Canada. The government claims, as does Mr. Bissett, that this law would put Canada in line with what many other countries do. In fact, very few comparable states reserve the right to revoke citizenship in cases of terrorism and treason and so on. The UK is the clearest example of a state that does grant this right, but in the last few years, the United States and Australia have both considered and rejected implementing such a provision. Those states that do allow revocation, Malta, Lithuania, Cyprus, Estonia, it is worth noting in those cases it is in disuse, complete disuse. Rather, the trend is to repeal revocation laws, as Luxembourg did in 2008, and to consign them to an era of history in which totalitarian governments assumed the authority to make citizenship decisions with impunity. As the government acknowledges, the law is limited by the European Convention on the Reduction of Statelessness signed in 1961. The revocation provisions in this bill thus apply only to Canadians who are dual citizens. 75% of dual citizens in Canada are naturalized Canadians. At least 150,000 Canadians are dual citizens by birth, including me. Yet this requirement formally protects. Yet while this requirement formally protects Canada's commitment to the Convention, it imposes an inequality, I do believe, between citizens who hold dual citizenship and those who do not. It does generate a second class of citizens who are more vulnerable to the powers of the Canadian state. In particular, dual citizens and single nationality citizens subject to the same crime will be subject to different penalties. Those with dual citizenships, including me, convicted of crimes, can be subject to disproportionately severe sentences, since they include the revocation of a status justly acquired. If punishment in Canada for severe offences is good enough for native-born Canadians, it is good enough for dual citizens. Finally, the bill grants the Minister of Citizenship and Immigration the discretion to revoke citizenship in too many cases. Currently, as written, the bill would give the Minister discretion to revoke citizenship in cases of fraud, but there is no requirement for a court to evaluate if fraud in fact did occur, as there was in the previous bill, or is currently enacted now. If the revocation provisions are kept, every such decision must be considered by or appealable to a court, even in cases where citizenship is revoked under suspicion of fraudulent applications for at least two reasons. First, some forms of apparent misrepresentation are made for legitimate reasons, that is, to escape genuine and real harm. Second, judicial proceedings provide the only mechanism by which to protect against the otherwise inevitable suspicion that the minister is using fraud as a reason to revoke citizenship of people who are suspected of aiming to harm Canada, where the proof doesn't exist. The 1961 Convention states the only conditions under which revocation can be just are where the affected individual is entitled to a trial, even in cases of fraud. The consequences of such citizenship revocations can be severe, regardless of the reasons for revocation. In two recent cases, as we all know, the UK denationalized two citizens, Mohammed Sakr, who was a British citizen by birth, and Bilal al-Barjawi, who were subsequently killed by American forces in Somalia. Sakr's lawyer reported that it appears, quote, that the process of deprivation of citizenship made it easier for the U.S. to then designate Sakr as an enemy combatant to whom the UK owes no responsibility whatsoever, end of quote. In my view, the right to revoke citizenship is a fundamentally corrupting power. The UK is now considering an even more drastic step of permitting citizenship revocation, even where it would lead to statelessness. We should avoid going down this road by removing this denationalizing power from the bill entirely. Thank you.
Thank you. Sorry that I had to interrupt you. We're now going to our question round with Mr. Menegakis. You have up to 7 minutes, sir.
Thank you very much. Up to 7 minutes. Good. We heard from some witnesses this. First of all, thank you, and thank you for appearing before us today, and thank you for putting up with the very short time frame we have, given that we had the vote in the House. We've heard from some witnesses this morning that a short visit, a short work period, or a study period are not the same. I believe that came from the witnesses from pre-PR time counts. In fact, not all stayed, and we know that, that come here for different purposes, but 87% basically use their permanent residence time to count, to meet their Canadian, their citizenship requirements. So, Mr. Bissett, my first question is to you, and I'd like to hear your comments about the flexibility that Bill C-24 provides by giving a 6-year period in which somebody can complete a 4-year residency requirement to become Canadian citizens. Can you comment on that, please?
Well, as I mentioned in my presentation, I'm in favor of this bill going one year beyond the current act. I think it makes sense to have a person wait for 4 years before applying for citizenship. The provisions in the bill are fairly strict, I think, in terms of that, including in the 4 years, they have to live at least half the year in each of those years before they can apply. I could see that creating some complications for people who conduct business outside of Canada, but I understand the spirit of the law is that you have to reside in a country for a period of time before you can really claim that you know that you're ready for taking up the responsibilities and the obligations and the benefits of citizenship. I would like to have seen it 5-year period, but I'd like to see perhaps a little more flexibility in the residential requirements, because I know myself a lot of immigrants who come here conduct businesses globally around the world. They're out of the country for often long periods of time. I would like to have seen something that would enable them to explain why they're out and why they have to be out, because there are people who, even under the current law, who are spending a lot of time in their own home country and a lot of time in Canada, but they miss out on the residential requirements. So I would like to see some flexibility in that, quite frankly. And I must say, I was impressed by the comments made at the end of the table about temporary entry, in a sense. I think that's a pretty strong argument. If someone has been here for 5 years at university in Ottawa or in Toronto or Winnipeg, then apply, as they can now do, for permanent residence from within Canada without going home, that period of time, I think there's considerable arguments why that period of time should count for something. Mm-hmm. Thank you.
Well, certainly there is flexibility here because we're allowing people to do that 4 years out of the last 6. So people working in and out of the country can, or that need to leave the country for whatever reason, can do so and still be able to accumulate their time. Mr. Khan, welcome back, sir, and nice to have you with us again. You stated in the outset of your presentation to us today that in principle you and your organization support Bill C-24. I wonder if I could ask, in your opinion, how does this bill, Bill C-24, help promote strong ties to Canada, core Canadian values, and attachment to Canada and Canadian citizenship?
I believe the aim of the bill is, of course, to do that, and we agree with it wholeheartedly. But at the same time, I didn't get a chance to elaborate. There can be a contributing member who's a permanent resident who may not have strong language skills in English or French, but could be a taxpayer, have no plans to return back to the home country of origin. Denying that person citizenship may not be the best choice. He may be somebody who contributes a large tax base to us. So there should be some subjectivity that's applied to this arena as well. But, of course, we're not saying that making a proper commitment to Canadian values, social values, multicultural values, must be present when one wants to have citizenship of this country.
Mr. Bissett, I want to expand a little bit on the point of revocation. A lot has been heard in this committee from different witnesses about the revocation provisions in this bill. Certainly, those that have a dual citizenship also have a dual benefit, I might add. It's not just to have a dual citizenship, they have a dual benefit. They have benefits that people that only have Canadian citizenship do not have. They have citizenship and rights in another country as well. Provisions in this bill provide, as you know, that Canadian citizenship can be revoked from those that have dual citizenship that choose to perpetrate an act of terror or an act of treason against the Canadian Armed Forces or Canada, a country that we all live in and we cherish so much. So we obviously, as a government, feel very strongly about that specific provision in the bill, and we'd like to hear what your comments would be on that, sir.
Well, I think I've made it clear that I support that wholeheartedly. You know, we hear about the Convention Against Statelessness, but let's face it, that convention was in 1954. Again, it was brought up again in 1961. That was a different world, in a sense. And I'm afraid, as someone once said, September the 9th, the events there changed the world. We're now faced with a situation where terrorism is quite a common occurrence, not only in the Mideast or in other parts of the world, but in Europe and in Canada as well. And I think that, as I said earlier, a dual citizen who makes the choice of committing acts of terror or treason or fighting against his own country should have the citizenship removed. There's no question in my mind about that. And remember, it's a question of someone who's been convicted, not someone who's suspected. These have been convicted.
Thank you. Now, Madame Sitze-Baisen, you have the floor for 7 minutes.
Thank you, Madam Chair, and thank you to all of our witnesses who are here. I'm going to start to take a little poll of everybody here. I know that, Ms. Sherbakova and Ms. Smirnoff, you made a very clear argument to favor the people who are here on temporary basis, committing to this country, being taxpayers in this country, educating and working in this country, and that time that they've spent should have some value for them if they choose to continue to stay in this country as a permanent resident like you are and continue to become a citizen. And we just heard from Mr. Bissett that he agrees with you, that there should be some value to that. I want a very quick answer from everybody else. If you think that there's actually value, and Mr. Khan, you mentioned that tax base is important and taxpayers are important, so these people are taxpayers in this country for 3, 4, 5, 10 years. It doesn't matter, not sure how long they're staying before they choose to proceed through a permanent or citizenship track. So I want to know if you think it's that those people in Canada who are educating and working in Canada have value, and that time should be valued for their citizenship track.
Talented individuals.
Really quick answers.
They're talented individuals. They have choices that they can go to other countries. Let's give them a reward for being here.
Great, thank you. Mr. Lamba?
Who he suspects is involved in a very strange term here. He can remove the citizenship of a dual citizen for reasons conducive of the public good, whatever that means. But the Home Secretary has a lot of power, and I think they've removed the citizenship of well over 30 or 40 British citizens, some of whom were born in Canada but who had adopted also the citizenship of another country. There are those who criticize this provision in the law because they claim it creates second-class citizenship. I don't buy that at all. There is an inherent difference between a natural-born citizen and a naturalized citizen. It's inherent in the process itself. But there are also other differences. A natural-born citizen has no choice. He's born into the citizenship, and he's stuck with that whether he likes it.
Fully endorse that they must be given the benefit of their education stay here.
Thank you. Professor Leonard?
Yeah, yes, I agree.
Thank you. And Professor Winter?
Fully.
Great. So all of
I agree.
Oh, okay, sorry. There's a little bit of a lag with the conference call, so my apologies. So this is great news to hear that a lot of, we've got civil society as well as educators here who are agreeing that we should be looking at giving some value to people's time that they've spent here in this country. I want to move on to the topic of revocation of citizenship. And the issue, not really the issue of statelessness, but the issue of creating 2 tiers of Canadian citizens, basically, because that's exactly what is happening with the revocation provisions for dual citizens. Professor Leonard, you started talking about this as well, and I was wondering if you could talk. You mentioned that I think it was you. I have notes that are going everywhere. That the government members have claimed that this would actually put Canada in line with many other countries across the world, and especially our sister countries. And I'm wondering if you know off the top of your head, or if you can send into the committee, which sister countries or countries around the world are we actually bringing ourselves in par with? And you mentioned that U.S. and Australia considered this revocation and actually turned away from it. So if you can actually talk a little bit more about that, please.
Yes, it's, I can speak about this at great length, and I'm happy to send the extra data to you.
Please send it to the clerk.
I'm happy to do that. The United States and the UK and Australia, considered both considered these within the last 4 years and turned it down. The United States Supreme Court declared that once an individual in the United States has citizenship, it cannot be revoked. It's for life in perpetuity, and the United States has stayed committed to that. And the sister country, I'm not 100% sure what the language of sister country means, so what counts there. There's approximately 14 European countries that allow revocation in cases of treason or terrorism. In most of those countries, it has never been used. The most sister-like countries that have it are Belgium and Denmark. They have those in both cases. Those are recently constructed. But mostly we're looking at states like the ones that I listed. That wasn't for rhetorical purposes. Lithuania, Estonia, Cyprus, etc. So,
thank you very much. And
point of order, Madam Chair. And say regarding the Supreme Court judgment in USA, it has been appealed against.
Sorry, Mr.
And it has been a constitutional law.
Sorry, I have to interrupt you. Madam Sitsabaysan can ask you questions too, but it's her time, so she will decide who she's asking question to.
Thank you. Thank you. I know I don't have much time left. The question that I had just ran out of my brain was... Oh, I know. How people are being potentially not being given citizenship or having their citizenship taken away for a crime or alleged crime that they had committed in another country. So what is happening is that I've been asking almost all of our witnesses this question about us as a state trusting another country's judicial system and trusting that their judicial system is actually independent and has legitimacy. Now, if Professor Winter or Leonard, if you want to talk about that, I don't know who of you might have some more experience or expertise in it.
I'm happy just to say that, I think there's two problems. One is that I don't think we should trust other judicial systems. In general, the judicial systems that are making accusations of these crimes are untrustworthy from a Canadian perspective. And secondly, I think if it's a Canadian looking at a revocation of Canadian citizenship, then he or she is entitled to Canadian due process.
Professor Winter, did you want to add anything? I saw you.
Yeah, I think I agree with Professor Leonard. I think citizenship really revocation is a punishment that really harkens back to a time that we no longer live in. It really destroys the relation between the individual and the state. And if we start by doing that, what other crimes should we start punishing by revoking citizenship? There are numerous heinous crimes that would deserve similar punishment. I think we're entering a very difficult and very kind of dubious territory here, and I think my legal colleagues from other universities have spoken to that issue at length.
Thank you. I know that I have 20 seconds, so what I'm going to do is ask you to actually submit your recommendations instead of what is in front of us because the study is on the issue of the law, not actually the bill, because the bill is not in front of the committee right now. But if you have suggestions of actual recommendations of changes to what is before us, then please do send it in writing to the clerk of the committee. Thank you so much.
Thank you, Madam Sitsabaysan. Mr. McCallum, you have the floor.
And how many minutes?
5.
5. Well, thank you very much, and welcome to all the witnesses. In all the committees we have heard, I don't think I've heard one with a broader spectrum of opinion in general, on things in general, and yet you are unanimous that international students should be credited with their time as students in becoming citizens. I don't think the government's going to change much, if anything, on this bill, but they might change that, because you should know, if you don't already, not only is the government not giving any credit to students, but they're taking away the 50% credit that already exists, and the 50% becomes zero. I think you all agreed on 100% credit, but even 50% is better than what we're going to end up with. Now, I did ask the minister that question when he was here, and he said he wouldn't change it, but he hadn't heard this very broadly diverse committee be unanimous yet. And the one argument he gave for his position was that for some reason, which I couldn't understand, time when you're a permanent resident counts, and time when you're not yet a permanent resident for some reason doesn't count. Now, I know Ms. Smirnoff and Sherbakova have done a really good brief on this. Can you very briefly, because I don't have that much time, refute that argument by the minister?
Oh, most definitely, and I appreciate you asking that question. We did hear Minister Alexander make the comment that there has to be a clear distinction made between someone who is a temporary resident and someone who is a permanent resident. But this view actually ignores the fact that the decision to become a permanent resident for those who are in Canada happens long before that permanent residency is received. So, for example, for international students, a student might make a decision to become a citizen of Canada after 1 or 2 years of studying here. After making friends, after getting work experience here, after maybe meeting a life partner here. And the problem is that the immigration system precludes this person from applying for citizenship until 1 year after they graduated from their studies. For permanent residents, I'm sorry. For example, in Taisia's case, she came here in 2004, she graduated in 2009. She could only apply for permanent residence in 2010, which she received in 2012. So, there's a system that really precludes these individuals from applying for permanent residence. And during this time, they're still in Canada, they're still paying taxes, they're still owning property and doing all those Canadian things. And now temporary workers, too, are affected by this. They also can't apply for permanent residency until after they enter Canada. And it's been proven multiple times that there's a number of obstacles that that they are not in control of, that further delay that. For example, closing of visa offices.
Sorry. I think you make a very good argument, but I'm about to run out of time.
Yeah, it's in the brief, actually.
In more general terms, I just think time spent here as an international student is not worth zero in terms of what you learn about this country and to equip you to become a citizen. Now, Professor Leonard, I certainly agree with you 1,000% in terms of your strong condemnation of citizen revocation. And I would just correct, I think, Mr. Menegakis, it is not true that you can only have your citizenship revoked if you're convicted, because there is a provision in the bill that if you participate in some armed group against Canada, which doesn't imply a conviction, whatever that means, you can also have your citizenship revoked. But just out of curiosity more than anything, Ms. Leonard, I'd also heard that story about the British people's citizenship being revoked, and then soon after they were shot down by drones in some faraway place by the U.S., Pakistan perhaps? Somalia. Is there any evidence that those actions were coordinated?
There's widespread suspicion, but no formal evidence that they're coordinated.
Okay.
What we know is that the UK government was entirely unwilling to have a conversation about what happened as a result of having denationalized those individuals.
Okay, and I think that pretty well uses up my time.
30 seconds.
30 seconds. Well, Mr. Khan, you were just at the end of your story when you didn't have much time. I heard your position on students on language. Are you saying that an English language test for people aged, say, 55 to 65 should not be imposed?
I would actually be more concerned with the younger age of 14 to 18. I think there should be some sort of test, but I think there should be some subjectivity applied to it. I think there should be a commitment to being Canadian. But
it seems to me a 55 to 65-year-old,
Mr.
their
Opitz, you
children will
have up to
speak
4
perfect
minutes
English,
before the
but they
committee
don't
ends, so please go ahead.
Thank you, Madam Chair. Well, you do have to be convicted, and it's compared to the Canadian system. And as a former soldier, I would take great umbrage to anybody from this country going over there and fighting against me and my troops and friends anywhere else. That's something that is an unbelievable development. And by the way, the reality is numbers of youth have been radicalized and have returned and have fought against many of our allies. So that's not outside the realm of possibility. So anybody in that category losing their citizenship, I'm not particularly concerned about that. So when it comes to arms groups like that. But, Mr. Bissett, last week the minister was here, and he had heard from stakeholders himself and local constituents, a broad range of Canadians across the country, and he was hearing quite loudly that they overall liked the proposed residency requirement because it strengthened the value of Canadian citizenship. And he said that Canadians appreciated that those who committed acts of terror, treason, as I just talked about, against this country would have their citizenship revoked on the grounds that they are dual citizens. Of course, we are signed up to the UN Convention, and we don't leave anybody stateless, so that's something that we do deal with. Can you tell me overall what you've heard, and would you agree that the value of Canadian citizenship would be strengthened through this legislation, through this act?
Yes, I certainly think so. I mean, as I said before, I think the average Canadian would be shocked and very much concerned if his neighbor was convicted of acts of terror or treason, or had gone off to another country to fight against Canadian troops or their allies. I think they would assume that he's lost his privilege of citizenship. He's abused it. I'm not sure there's been any polling on that, but I'm pretty sure that the vast majority of Canadians would agree with it. I think Professor Leonard may not agree, but I think so. I think it's one thing for academics to think that this is a very serious matter, but in my own view, it's something that's self-evident.
Well, I think we agree on that, and I think the vast majority of Canadians would. Now, our government takes immigration policy clearly very, very seriously, and we've made a number of reforms to the Immigration and Refugee Protection Act in order to protect the safety and security of Canadians, obviously. Well, we have welcomed a number, in fact, a record number of immigrants and EU citizens since 2006, and our government, we had welcomed over 1.4 million new citizens, and even since the beginning of 2014, 75,000. How would you say Bill C-24 would support a newcomer's integration into the Canadian economy and into communities, and to ensure that that our new citizens would have a stronger and deeper attachment to Canada?
Well, I think the fact that they'll have to wait a year longer than they used to is an added benefit in conditioning them to Canada and Canadian society and Canadian values. So I think it definitely will help in that regard. And I think that's important because, in the 1977 Act, Canada has drastically changed demographically since then. And since 1990, 5 million newcomers have come to Canada. And they're not coming from the traditional European countries that used to supply us with 99% of the immigrants. That changed in 1967. As a matter of fact, I was on one of the originators of the point system that enabled us to go out to the world and welcome people. Having said that, I still think that 3 years is not enough time for a person to suddenly decide that they are ready to take on the responsibilities and obligations of citizenship. So I welcome the additional period of time. As I said in my presentation, I don't think it's quite long enough, quite frankly.
Thank you very much. Une fois encore, je suis désolée pour les inconvénients du changement.
Once again, I apologize for the scheduling changes.
Very important contribution to our study on the subject matter of the bill C-24. Sur ce, je déclare la réunion adjournée. Merci à tous.
This meeting now stands adjourned. Thank you.